What are the steps involved in the divorce process?
Let me provide you with the basic outline for a typical divorce case. First, you're going to complete your contract, pay your retainer, and provide us any documents that we need to get to work for you. We will then create your first pleading, which is going to be a complaint for divorce or a response and counter complaint for divorce. Then we wait. We wait for the court to schedule the case management conference. The case management conference is the first hearing in your divorce case. However, hearing can be a little misleading depending on your judge or jurisdiction. Most judges prefer to meet with both the litigants and the attorneys. Some judges prefer to meet with just the attorneys. And some judges prefer to let their judicial assistant meet with the attorneys to talk about whether there's been a settlement or what issues need to be addressed. A scheduling order is the product of the case management conference, and one of the things that will be scheduled is mediation. Mediation is going to be ordered by your judge if you're unable to resolve your case by the end of the case management conference. Mediation, by and large, is a pleasant experience. It's informal and it's non-binding, which means you can't be compelled to agree to anything. I've heard that as much as 98% of cases are resolved by the end of the mediation stage in our area. This means mediation is an opportunity. It's an opportunity to avoid trial and the expense that comes with trial. It's an opportunity to end the fighting and the hostility and to move on with your life. Mediators in our area are usually family law practitioners themselves and have a lot of experience with resolving cases. If you resolve your case at mediation, it'll be turned into a written document, your divorce decree, which everybody will sign, and we'll submit it to the judge. If we're not able to do that, we'll talk to the judge about it at the status conference. The status conference is the last check-in with the judge before scheduling trial. One of two things is likely to happen at your status conference. One, you're going to have an agreement, we're going to put the proofs on the record, and your divorce is going to be finished most likely that day or shortly after. Or the judge is going to schedule trial. Despite our best efforts, we're going to trial. This is unfortunate because trials are expensive. You can expect to spend at least $10,000 to $20,000 on a trial. That's on top of all the fees you've already paid. Why? Because something like this, which takes about 15 hours to create, will be required by your judge and have to be shared with the opposing party. We'll have to prepare examination and cross-examination questions. We'll have to prepare you for the trial. We'll have to prepare witness lists and exhibits. It's an expensive process that should be avoided as often as possible. It's why we resolve 98% of the cases in our area before trial. Most people can't afford a trial. If you have the opportunity to resolve your case anytime before being ordered to trial, do it. It's going to be better for you, better for your family, and a lot better for your pocketbook. One thing that I failed to mention earlier is that if there are minor children involved in your case, you're likely to spend some time with a friend of the court referee who will address interim custody, parenting time, and child support issues. Divorce is complicated. Divorce takes a long time. I know you wish the pain and the fighting and the frustration could be over quicker, but sometimes it's just not possible. Downriver Law Center is committed to efficiently and effectively representing you to try and resolve the case as early as possible. But a lot of that will have to do with you and your spouse. We'll do everything we can to help you.
Downriver Law Center, quality legal services.